Hello friends, I am here to give presentation on citizenship under Indian Constitution. In this module, learners would be able to understand the concept of citizenship in India. Learners would get to know that the Indian citizenship can be acquired through various ways like citizenship by birth, citizenship by domicile, citizenship by migration, citizenship by registration, being son or daughter of parents of Indian origin, citizenship by marriage, etc. Now let's start with the introduction part. A citizen enjoys fundamental rights including right to work, right to vote, right to return, etc. in his or her country. At the same time, the citizen is also bound to observe certain duties of citizenship. It reflects that the right to citizenship is not an absolute one, and the legislature may impose reasonable restrictions on the enjoyment of one's citizenship. Every country has its own immigration laws which regulate the entry and stay of immigrants. Right to participate in the government is also being regulated by the immigration laws. For this, the countries differentiate between nationality and citizenship. However, it has also been seen that the countries sometimes make strict immigration laws and exclude foreigners on the discriminatory basis. And that's why the international conventions and other instruments have check on such immigration laws. There are many ways of acquiring citizenship of a country. A citizenship can be acquired by birth, by marriage, on honorary basis, etc. But immigration laws nowadays are strict in order to regulate false marriages, where people marry each other for money or other benefits. States can also grant honorary citizenship. For example, Canada will offer honorary citizenship to Pakistani teenage activist Malala Yousafzai. Malala will become just the sixth person to be granted honorary Canadian citizenship after South African anti-apartheid hero Nelson Mandela, Nobel Peace Prize laureate Aung San Suu Kyi, Tibetan spiritual leader Dalai Lama, British business magnate Aga Khan, and Swedish diplomat Raoul Wallenberg. Now, citizens are full members of the state. These citizens enjoy full civil and political rights. Aliens are not entitled to all constitutional and other rights because they are not citizens. For example, in India, aliens, the foreigners, they have right to life and personal liberty. Obviously, that cannot be disregarding to them, but not the freedoms granted under Article 19 of the Indian Constitution. Under Article 21 of the Indian Constitution, they have not used any specific term, but they have used the word person. So, person includes aliens. So, we cannot misbehave with the aliens, or the law enforcement agencies cannot violate their fundamental right to life and personal liberty whenever they enter our territory of India. Furthermore, enemy aliens suffer many more difficulties. In India, enemy aliens cannot enforce Article 22 of the Indian Constitution, which protects the rights of the accused persons detained under preventive detention laws. Now, stateless persons are persons who are not citizens of any country. Their status is similar to aliens. In the present module, the Indian constitutional provisions relating to the subject of citizenship have been discussed in the detailed manner. Rights of the Indian citizens, non-resident Indians, and overseas Indians have also been analyzed. And it has focused on the issue that how Indian citizens enjoy more rights than non-resident or overseas Indians. Recent issue of voting rights of non-resident Indians has also been discussed in the module. Now, in India, citizens enjoy full civil and political rights. There are certain fundamental rights which are available only to the Indian citizens. An Indian citizen has the right not to be discriminated against any citizen on ground of religion, race, caste, sex, or place of birth. the right to equality of opportunity in the matter of public appointment, the right to 6 freedoms enumerated in Article 19 of the Indian Constitution, and the culture and the educational rights, they are available to the only to the Indian citizen and not to the aliens. Furthermore, there are certain constitutional positions which belong to Indian citizens only, like the office of the president, the office of the vice president, the office of the judges of the Supreme Court or of High Court, Attorney General, Governor of a state, Advocate General of a state. Again, an Indian citizen has political rights, including the right to vote, right to contest elections, etc. And Article 15 of the Indian Constitution. Article 16 of the Indian Constitution, Articles 29 and 30 of the Indian Constitution, Article 58 of the Indian Constitution, Article 67, Article 124 Clause 3, Article 217, Article 76 Clause 1, Article 157 and Article 165 are discussing these things. The matter of citizenship was discussed in detail at the time of making of the Indian Constitution. The constitution makers, they considered the willingness and unwillingness of all people regarding their stay in India. It was strictly determined whether they want to settle permanently in India or not. However, Dr. B.R. Ambedkar recommended that the Parliament should make a law over the matter of citizenship. But he further emphasized on one of the fact that such law should not be permanent. Currently, despite the fact of its federal structure, India does not provide dual citizenship. There is only one single citizenship, that is Indian citizenship. The Indian Constitution does not define citizenship. It describes classes of persons who became automatically the citizens of India at the time of the commencement of the Constitution. It is the Parliament who has an authority to make law on citizenship. In exercise of its power, the Parliament has enacted the Indian Citizenship Act 1955. Now, Article 5 to Article 11 of the Indian Constitution lays down as to who are the citizens of India at the time of the commencement of the Indian Constitution. In India, the citizenship can be acquired through various ways, like with citizenship by birth, citizenship by domicile, citizenship by migration, citizenship by registration, being son or daughter of parents of Indian origin, citizenship by marriage, etc. Article 5 of the Indian Constitution made certain persons as Indian citizens at the time of the commencement of the Indian Constitution. The first condition to be an Indian citizen is of domicile, that is, a person has domicile in the territory of India. The term domicile has not been defined in the Indian Constitution. Domicile means the place where a person's habitation is fixed without any present intention of moving therefrom. Every person has a domicile at his birth called the domicile of origin. The domicile of origin remains unchanged until the person acquires a new domicile, that is, by actually settling in another country with the intention of permanently residing there. Till then, the domicile of origin continues even if he has left the country with an intention of never returning again. The onus to prove that a person has changed his domicile of origin lies upon him. It has also been held by the Supreme Court that there must be factum and animus to constitute the existence of domicile in India. Similarly, the Supreme Court said in Louis versus Union of India that the person should show his appropriate state of mind required for acquisition of domicile by choice. In Pradeep Jain versus Union of India, the Supreme Court held that there is only one domicile in India. The court said that the domicile does not change with the change of residence within India. So one can move within India, and if he is moving within the territory of India, we cannot say that he has changed his domicile. A minor or married person does not have the legal capacity to make a change of domicile. Therefore, a minor carries the domicile of his father and a married woman gets the domicile of her husband. Article 6 of the Indian Constitution, it provides for the rights of citizenship of certain persons who have migrated to India from Pakistan. Article 7 provides for rights of citizenship of certain migrants to Pakistan. Famous judgments regarding Indian citizenship are of Indian Supreme Court are as follows: Central Bank of India versus Ram Narayan 1955 judgment, Kedar Pandey versus Narayan Bikram, it is a judgment of 1966, Michael versus State of Bombay, it is of Bombay High Court judgment in the year of 1956, Naziran Bani versus State of MP, it is a judgment of 1975, Karim Nusa versus State of Madhya Pradesh, it is a judgment of High Court in the year of 1955. Now both Articles 6 and 7, they use the term migrated. The meaning of the term migrated came into consideration of Supreme Court in case of Kulathi versus State of Kerala. The majority held that the word migrate was used in a wider sense of moving from one country to another, with the qualification that such movement was not for a short visit or for a special purpose. Article 8 of the Indian Constitution, it provides for the rights of citizenship of certain persons of Indian origin and residing outside India. Now Article 9 of the Indian Constitution, it provides that no person shall be a citizen of India by virtue of Article 5 or be deemed to be a citizen of India by virtue of Article 6 or Article 8 if he has voluntarily acquired the citizenship of any foreign state. It deals only with voluntary acquisition of citizenship of a foreign state before the Constitution came into force. Under Article 10 of the Indian Constitution, Parliament may take away the right of citizenship of any person. Article 11 of the Indian Constitution, it further gives a proper way to the Parliament for making any law relating to citizenship. While exercising the authority, the Parliament enacted the Citizenship Act 1955 for the acquisition and termination of the citizenship in India. The Parliament has enacted Citizenship Act 1955 to provide for the acquisition and determination of Indian citizenship. The Act provides for the acquisition of Indian citizenship after the commencement of the Constitution in 5 ways, that is birth, descent, registration, naturalization and incorporation of territory. A person acquires citizenship by birth if he is born on or after 26 January 1950 but before 1st July 1987. In this case, there is no need to determine the nationality of his parents, but in case where he is born on or after 1st July 1987 but before 3rd December 2004, it is necessary that either of his parents is a citizen of India at the time of his birth. After 3rd December 2004, He acquires citizenship by birth if both the parents are citizens of India or one of the parents is a citizen of India and the other is not an illegal migrant at the time of his birth. An illegal migrant means a foreigner who entered India without a valid passport or documents or remains in India beyond the permitted period of time. Now, let's talk about citizenship by descent. Section 4 of the Citizenship Act 1955, it provides that a person born outside India on or after 26th January 1950 but before 10th December 1992 is a citizen of India by descent if his father was a citizen of India by birth at the time of his birth. A person born outside India on or after 10th December 1992 but before 3rd December 2004 is considered to be a citizen of India if either of his parents was a citizen of India by birth at the time of his birth. A person born outside India on or after 3rd December 2004 shall not be a citizen of India unless the parents declare that the minor does not hold passport of another country and his birth is registered at an Indian consulate within 1 year of the date of birth or with the permission of the central government after the expiry of the said period. Now, under Section 5 of the Citizenship Act 1955, a person who has been ordinarily residing in India for 7 years before making the application or who has been ordinarily residing in any other country outside undivided India would require Indian citizenship by registration. A person can also register himself or herself as Indian citizen if he or she gets married to an Indian citizen who has been ordinarily residing in India for 7 years before making application. Both minor and major children of Indian citizens could also acquire citizenship by registration. A registered overseas citizen of India for 5 years and who has been residing in India for 1 year before making application would also get citizenship by registration. Citizenship of India by naturalization can be acquired by a foreigner and obviously he should not be an illegal migrant who is ordinarily resident in India for 12 years. The Citizenship Amendment Act of 2003 provided for acquisition of overseas citizenship of India by persons of Indian origin of 16 specified countries other than Pakistan and Bangladesh. In 2005, the Act was further amended in order to grant more and more overseas citizenship of India to persons of Indian origin of all countries except Pakistan and Bangladesh. By this amendment, the earlier requirement of period of residence in India was also reduced from 2 years to 1 year for persons registered as overseas citizens of India to acquire Indian citizenship. The Overseas Citizenship of India scheme was introduced by amending the Citizenship Act 1955 in August 2005. The scheme was launched in the year of 2006. The scheme provides for registration as overseas citizen of India of all persons of Indian origin who were citizens of India on 26 January 1950 or thereafter or were eligible to become citizens of India on 26 January 1950. but the scheme excludes citizens of Pakistan and Bangladesh. Now, overseas citizen of India does not mean dual citizenship. Overseas citizen of India does not confer any political right on the concerned persons. The registered overseas citizens of India cannot enjoy the same status as that of Indian citizens in case of equal opportunities in the public employment. It means overseas citizen of India cannot enforce Article 16 of the Indian Constitution. Furthermore, overseas citizens of India cannot enjoy voting rights. Overseas citizen of India cannot enjoy the right to hold offices like President, Vice President, Judge of Supreme Court and High Court, Member of Lok Sabha, Rajya Sabha, Legislative Assembly or Council. Overseas citizen of India cannot be appointed to the public services. However, overseas citizen of India enjoys some other rights. A registered overseas citizen of India gets Indian visa for his whole life. He or she enjoys the same status as that of non-resident Indians. In matters of inter-country adoption, tariffs in domestic airfares, entry fee for visiting national parks, the national monuments, museums, etc. in India. Overseas citizen is eligible to practice professions of doctors, dentists, nurses, pharmacists, advocates, architects, chartered accountants in India. But overseas citizen of India does not enjoy the same parity with non-resident Indians in matters of agricultural properties. Now, there is a provision of renunciation, termination and deprivation of citizenship. Section 8 of the Citizenship Act 1955 provides that a major and capable person can renounce his or her Indian citizenship. On renunciation, his minor child also loses citizenship, but the minor child can resume the Indian citizenship by after attaining the age of majority. Then we have section 9, subsection 1 of the Citizenship Act 1955, which provides that an individual Indian citizen loses his Indian citizenship if he or she acquires the citizenship of another country. It has also been held by the Honorable Supreme Court of India in the case of Prasad Dikshit versus Rajiv Gandhi 1986 that the section 9 is a complete code regarding the termination of Indian citizenship on the acquisition of the citizenship of a foreign country. Now, on renunciation or termination, the concerned person has to surrender his or her Indian passport to the authorities under the Passport Act. If he or she fails to do so, he or she is liable to receive prescribed punishment. Now, deprivation of citizenship means compulsory termination of citizenship in India. Section 10 provides that the central government may terminate a person's citizenship on certain grounds, like the person commits fraud in registration, the person is not loyal towards the Constitution of India, the person is trading or communicating with enemy when India is at war, the person's citizenship is not in favor of public good, etc. So there are so many grounds on which the person's citizenship can be terminated. Increasingly, in the case of Hari Shankar Jain versus Sonia Gandhi, it's a recent judgment in the year of 2001 Supreme Court, the Honorable Supreme Court opined that a petition to challenge one's citizenship can be filed before the High Court or election judge. Now, so far as non-resident Indians' voting rights are concerned, Parliament has approved voting rights to non-resident Indians in elections, with the Lok Sabha adopting the Representation of the People Amendment Bill 2010. However, the non-resident Indian has to be present in the constituency on the date of polling. The new law would allow an Indian citizen residing abroad to get himself enrolled in voters list even if he or she was not in India for more than 6 months because of employment, education, or otherwise. However, in the present busy world, it seems unreasonable when non-resident Indians have to come back to India from abroad just for casting their votes. Therefore, it is submitted that there is a need to computerize the voting rights of non-resident Indians. Now the question arises whether a corporation is a citizen or not. In the year 1963, in the case of State Trading Corporation versus Commercial Tax Officer, the Honorable Supreme Court of India held that company or corporation is not a citizen of India and cannot claim fundamental rights. The court said that citizenship is concerned with natural persons only. The court said that citizenship cannot be conferred upon the juristic persons. However, in the year of 1970, the Honorable Supreme Court of India, in the case of Cooper versus Union of India, this case is also known as bank nationalization case, in which it was held that a shareholder of a company should be considered as an Indian citizen and is entitled to the protection given under Article 19 of the Indian Constitution. The fundamental rights of the shareholders as citizens should not be violated by any state action. Another very famous case which came in the year of 1973, that is a Bennett Coleman and Company versus Union of India. The Honorable Supreme Court again said that the state action not only affects the right of newspapers companies but also of the editors, readers, and shareholders. These individuals do have freedom of speech and expression, which should be protected against any unreasonable state action. So it was basically a very landmark judgment in case of fundamental freedom of speech and expression. Once freedom of speech and expression should not be violated by any state action, and there is no need and there is no justification to draw out any differentiation between whether that press is a corporation and he is not a citizen or not. The purpose here is that freedom of speech and expression should be protected. In Godhra Electric Company Limited versus State of Gujarat, 1975 judgment, the Honorable Supreme Court of India held that a managing director of a company had right to carry on business through agency of company. The court said that he had right to challenge the constitutional validity of the concerned enactment. Following bank nationalization and Bennett Coleman cases, the Supreme Court in DC and GM versus Union of India 1983 judgment has held that writ petition filed by a company complaining denial of fundamental rights granted Article 19 is maintainable. So in this module, we have discussed the concept of citizenship, that how this citizenship of a country can be acquired, and in India especially we discussed the Indian position, that how citizenship in India can be acquired, and how we in this module we have also discussed the status of the non-resident Indians, and how they are acquiring the different position than the overseas citizenship. There are many other current issues which have, although has not been discussed in this module, but still they are nowadays very burning topics. For example, the many countries, they are refusing any kind of refuge to the climate refugees or any other political opponents or whistleblowers or any other political activists, or the persons who has been persecuted by their home country. So these things are one of the issue. And in this module we discussed the Supreme Court's famous judgments in which they protected the rights of the shareholders, although they are working in some company, while declining this contention that corporation is not a citizen. The Supreme Court of India has protected Indian citizen shareholders' fundamental rights. With this, I conclude this thing. Thanks.